لله نحمده ونستعينه ونستغفره ونعوذ بالله من شرور أنفسنا ومن سيئات أعمالنا من يهده الله فلا مضل له ومن يضلل فلا هادي له وأشهد أن لا إله إلا الله وحده لا شريك له وأشهد أن محمدا عبده ورسوله صلى الله عليه وعلى آله وأصحابه ومن تمسك بسنته إلى يوم الدين أما بعد. So as we continue to discuss the book Al-Malakis al-Fiqhi by Shaykh Salih Fawzan Hafidullah Ta'ala, and we'll be continuing discussing the topic concerning al-mawarith, so matter referred to as fara'id, things relating to inheritance. So we'll pick up from where we had stopped last week and continue the discussion. Tafaddal.
Bismillah wa salatu wa salam ala Rasulillahi. Qala ma'allif hafidahullah, chapter 4, page number 245, title Causes of Inheritance and the Legal Inheritors. Inheritance is the transfer of the legal possession of a deceased person to his heirs, according to the laws of inheritance ordained by Allah. There are three causes of inheritance. Number 1, blood relationship. Blood relation refers to the relation between two persons by birth rather than by marriage. No matter how far or near the relationship is, as long as nothing or none blocks them from receiving their prescribed shares. Allah exalted be He says, but those of blood relationship are more entitled to inheritance in the decree of Allah. Surah Al-Anfal, Ayat 75. Blood relationships include the forefathers, the offspring, and the collateral relatives. The paternal forefathers include the fathers, the paternal grandfather, and so forth in ascending lineage, who are linked through males to a common ancestor. The offspring include the son, the grandson, by the son, and so forth in descending lineage. The collateral relatives include the brothers and their children, no matter how far down they descend, as well as paternal uncles, sons of paternal uncles, cousins, and so forth in a descending lineage.
So here the Shaykh Hafidullah, they started discussing concerning matter relating to, as mentioned as the chapter heading, fi asbab al-irth wa bayan waratha. So regarding concerning matters regarding al-irth, which is concerning inheritance, or those things that have been left behind, how it is to be distributed. So the ways of how to distribute and to portion out what have been left behind. So Shaykh mentioned min asbab al-irth thalatha, so of ways of inheriting from someone or receiving from this wealth or this inheritance is to by three ways. So it's three ways that one can acquire something through by way of inheritance. Then they mentioned, the ulama mentioned granted these three ways, asbab, they mentioned here, mujma alayh. So these three ways that are mentioned, that these are agreed upon between the ulama. So the three that are, the Shaykh mentioned, so the first of those he mentioned, al-rahim, which somebody mentioned quraba, which is concerning the people that you are actually related to, where they mentioned, ittisal bayna insanin aw shakhsayn. So two persons being connected بين باشتراك في الولادة, by way of they share same lineage or womb. So they are attached by way of sharing the same lineage. So this is called concerning al-rahim, that others also refer to as al-nasab. So in some of the books they were mentioned, instead of al-rahim, they use the word al-nasab by way of lineage. Then Shaykh mentioned, as for concerning al-rahim, that تشتمل على الأصول والفروع والحواشي. So regarding concerning that this relation or family ties, that is divided also into three, either by way of usul, furu, wal hawashi. So they mention usul, they are the fathers and grandfathers, grandmothers, and the like. So they are considered to be of the so concerning the fathers and grandfathers, they are the usul. As for the furu, that they mention al awlad are the children and grandchildren. Then they mention hawashi, they will be concerning al ikhwa, your brothers, and also your nephews. So that's concerning, and also they include concerning Imam, which are the paternal uncles. So these are regarding family members that divide into three. Those who are the usul, the parents and grandparents, furu, the children and their offsprings, which are the grandchildren, and then we have also hawashi, and there will be the brothers and their children, and also uncles and the likes. Aywa.
Number 2, marriage. The marriage must be according to a correct, valid contract of marriage, even if there is no consummation of the two spouses have not yet met in privacy. This is due to the statement of Allah, exalted be He, and for you is half of what your wives leave if they have no child. But if they have a child, for you is 1/4 of what they leave after any bequest they may have made or debt. And for them, i.e. the wives, is 1/4. Surah An-Nisa, ayat 12.
So the Sheikh mentioned a second way of inheriting from another person is by way of nikah. So they mentioned in regard that the second way is by way of nikah, by way of marriage. So they find concerning that what is deemed to be a marriage, so the marriage is to be a valid marriage. So mention al-aqd zawjiyya as-sahiha. So it's al-aqd al-zawjiyya, where it is a valid marriage that have taken place. So it should be a legal or an Islamic marriage that is recognized Islamically that have occurred for you to be able to inherit it from that person. So by way of marriage, then you can inherit it from the person. I mean, the husband can inherit from his wife, and his wife inherit from the husband. So find that they mention that, but also that marriage is considered to be legal, we can inherit from your wife, that it doesn't necessitate, it's not a requirement that you have to have intimacy, or that you were left alone. So by the fact that you got married, the marriage contract was finalized, even though you may not have intimacy, or you were private with her, the fact that you have a legal marriage, then she can and you can inherit from each other. What I mentioned,
So you see the amounts that they've stipulated in here, yeah? 1/4. Is that the same in divorce as well? So if two people get divorced.
So in the case of divorce, so if they divorce, that she's not per se, if a couple were married and they divorce, then there's no inheritance that is shared between them. Yeah, because I said, except for one condition, one case that we might discuss concerns to that general case, that if you have a valid divorce that have occurred, then that wife does not inherit from you, but the children does, if you have children between yourself.
Yeah. But you see, in terms of like two people get divorced,
and they go separate ways and move on in life.
Say, for instance, she has 10,000 in her bank, or he has 10,000.
Yeah, and that's her money separate. For the divorce.
That's it. Everyone just leaves with their stuff.
Yeah, everyone take their stuff and go. Except we said in one case that maybe to be discussed, where that if, for example, the husband might divorce his wife, or the wife divorce the husband while they were like very in a ailment, they were ill and they're trying to it says, bar that person from inheritance.
Okay.
You understand? So they trusted a person who's now, sly way, unwilling, that they're trying to bar that person. Then those in those cases, then even though there's a divorce with certain condition, that one, for example, the husband, he was ill and he decided that to divorce his wife for no valid reason, but he just trying to bar her from not inheriting from him. So in those cases, if they find that in a spiteful way, then if she did not get remarried to someone else, or she's still upon Islam, then she can receive from his inheritance.
Okay.
But in a general rule, if they're divorced, then all rules of inheritance does not apply.
The two spouses inherit from each other according to the aforesaid verse, and also in the case if a revocable, how do you say that word?
Revocable
divorce pronounced as long as the woman is still in the waiting period, for during the waiting period the woman is still a legal wife.
So what is meant by this concern that, okay, continue, tafaddal.
Phrase correct contract of marriage excludes the incorrect contracts of marriage, for the right of inheritance arises from only a valid contract of marriage, and the incorrect marriage does not affect the rulings on inheritance. So
meaning concern that if in case of divorce was to occur, so more tafsil, that if a divorce was to take place, and you have divorce of two types, one which concerning al-bahin wa ghayr al-bahin. So you have the divorce of raj'i, where the husband, he divorced his wife, but she has an iddah, for example, 3 months or 3 cycles. Within, if he was to divorce her then, and something was to occur with him, if, for example, he passed off, or she, then they can still inherit from each other because they're still technically married.
Right, yeah.
So the case of a talaq al-raj'i, where they have a waiting period of, so they said 3 months, or for example, she's pregnant and it goes until she delivers, because they're still technically married, they're still considered to be husband and wife, but going through a divorce. Now, if anything happened, that they can still inherit from each other because they're still technically married.
Yeah.
But you have now the second type of divorce al-ba'in, where they're now separate, they're now complete, they can't remarry each other. Then that's a different, then they doesn't inherit in that case.
Okay.
They do not. Or they have cases concerned that divorce may occur, or they're married, but there was some technicalities that with the marriage was not done correctly. So for example, she married and there was no wali. So that marriage is considered to be something that is fasid because that there was no wali involved. Now, so the girl and this boy get married. These are 2 witnesses, and there was no wali at all was involved. Then that marriage is invalid. So even though they was thought to be married, but legally, Islamically, they're not married. Now, so that marriage, they cannot inherit from each other because the marriage was not done in a valid way. Now, another case that they got married, and I will discuss this. The Bab after this, we'll discuss concerning ahkam nikah. After this, we'll go more detail that if they were to get married and the mahar was not given or not even mentioned, so that marriage is still valid, they can still inherit from each other because the nikah was still valid, even though it did not per se mention the mahar, stipulate whether the mahar or identify what would be the given mahar, or did he identify but they haven't paid it. That marriage is still valid. That marriage is still valid, and the rules of inheritance still applies. Nam. Aywa.
Number 3, the wala, the freed slaves, loyalty.
So it's the contrary to what we find in the Western, in the sense that the fact that they get married and she deserving half of your property, then that's not in Islam.
Yeah.
You understand? She's deserving, but not necessarily half. Nam. Depending on the situation and circumstance. That's not, or vice versa. Aywa.
Number 3, the wala, the freed slaves' loyalty by virtue of emancipation. It is a relationship between...
No, sorry. In the waqf is that she's deserving half, even if you're still alive. So this is inheritance with the person or passed on. So she just automatically, if she divorce you, she can get half, even though you're still alive. So that's their system with Islam. This more concerning the person or passed on, husband or passed on, then the proportion would be mentioned soon after, inshallah.
What is, sorry to cut the lesson, but what is the situation regarding marriage? Is it just, unless the person's sick and they're trying to cut them out of inheritance, everyone just leaves with their stuff and goes their separate way, and then you just work out a way to maintain or
Yes, so we discussed like an ahkam and the talaq. For example, the divorce occur, you're married and you divorce. So during the iddah, right, then, because we said the end of talaq al-raj'i, if he's also, which is a divorce have been pronounced, but she has, between them, he has a 3 months, it's a 3 months or 3 cycle for him to take her back. They call it raj because he can take her back. But because they're still technically husband and wife. So he still maintain her.
He still provides
and provide for her. Then if he decide after that 3 months the iddah comes to an end, then khalas, then there's no maintenance, that he doesn't have to maintain her. They're 2 separate strangers. Unless there's children involved, then the maintenance is for the children, not per se for her.
Yeah.
Clear?
Because there's some people that they think that, I don't know whether Western mentality, that if either people have money, let's split our money down the middle.
No, that's not the case. Hey, that's not the case. Yes, so that's not the case concerning that you have to go. So that's not the case. Islamically.
It is a relationship.
That would only apply if they was in business in something.
So that if husband and wife are in business, you understand? So they're husband and wife, but they have their own as their partners in some business. So it goes back now. So their divorce is one thing. That business they can still remain as business partners. Or if they choose now to break that contract between themselves, then it goes back to how the contract was made regarding how things to be divided if they were to split. Regarding how the business was to be dissolved. So both are looked at separately, not one attached with the other.
What was that? It is a relationship between the master and the manumitted slave, in which the former inherits any property that the latter may acquire due to the former's favor done to the latter. Their inheritance is from only one side, i.e., if the manumitted slave dies, the emancipator inherits from him and not vice versa. If the emancipator dies, then his universal heirs by oneself and not co-universal heirs inherit from this manumitted slave. To illustrate, the Prophet ﷺ said, "The wallah is a bond like that of kinship," related in Ibn Hibban in his authentic book of Hadith, and also related and deemed Sahih, authentic by Al-Hakim.
Yeah, the hadith is under some discussion between the ulama regarding that particular hadith. We find that some of the ulama regarding al-wala. So they're discussing the third form of how you can inherit from a person, which is called wala. So wala is of two. Wala would be either that a person who have released a person or you have emancipated a person. So a person like on the slave, what was it, unfree person, and you release him. Nam? So the person will release him because of that kindness towards that person that you have released, emancipate, then also you can inherit from him. If he has any wealth, because now he's a free person. Nam? So if he was to acquire wealth, being a free person, then you are now, some of his wealth can be passed or you can inherit from him, not vice versa. Nam? So you have that wala concerning, so that relationship because of that bond between them is based upon wala, which is a form of like wala will be concerned to that form of like so a bond between both of them based upon a certain type of relationship of you releasing the person. But also you have wala. So in that case only of wala, you can inherit from the person. In the other case of wala, for example, you find that a person go to give dawah in a place, and those people accepted Islam from you, then they can take on your name because they accepted Islam from you. But there's no rule of inheritance or bond of inheritance that apply. It's just that they can take on like your name because they took Islam from you. Like Imam Bukhari, you understand, his ancestors, because the people al-Jufil, so you find those cases. So we'll have two types. So the one that is being discussed is the first category where if you released what call the word? An unfreed person. Then that crossover where you can now the Sharia allow you to inherit from that person. But we mentioned the hadith here is under discussion, the hadith of Ibn Omar that is mentioned by Ibn Hibban wal Hakim and others who have narrated the hadith, that Shaykh Albani and others who have authenticated the hadith based upon the hadith as being marfu' in some narration. Even though Shaykh Albani will discuss the hadith in Idawa, that he mentioned in the isnad here that is mentioned, in it you have individuals who are said to be daif. But based upon other narration that day, and some of the ulama, the hadith to be mawquf, meaning the hadith goes back to Sa'id ibn Musayyib, not per se the hadith going back to the Prophet ﷺ. So you have that discussion around that hadith with some detail. Aywa.
Thus he, sallallahu alayhi wasallam, made the wala similar to blood relationships. Therefore, the wala is a cause for inheritance like blood relationships, according to the consensus of Muslim scholars. Moreover, it is related in the two Sahih that the Prophet ﷺ said, "Verily, the wala is for the emancipator."
Aywa, so that's hadith in Sahih Bukhari, hadith of Aisha radiallahu anha, Bukhari and Muslim. So also you find that with Islam, regarding consider, we mentioned that in certain cases that Islam allows a certain type of people may be strangers, but the rules may change due to certain things. So find that wala is of those cases where the rule change even though you have no blood type of a person, but because you emancipate or free that person, then you are somewhat bounded together like family, but even though you're not family. And of those things extend to inheritance. Also, you might find that in cases regarding consider, we discussed in Akamul according concerning nikah, that two strangers, if they're breastfed by the same lady, even though you're not brothers and sisters, you become like brothers and sisters. So you have certain cases where the rule changes for people who are strangers due to that they share in certain particular things. So this is of those cases. It's strangers, but the rule somewhat changes due to certain things that may have occurred between both parties. Aywa.
Inheritors according to gender. Inheritors are divided into male and female heirs. Male heirs are 10.
So the Sheikh now discussed concerning, so the first thing that they discussed concerning that concerning that who are those people, concerning ways in which you can inherit from a person. So to legitimately inherit from a person's wealth, then it should be three of those. You have to look at those three factors. Either you are related to that person by way of blood ties, second by way of marriage, and third by way of wala. Then he mentioned now the sex, then he mentioned the adilla to prove of those things. Then he mentioned here regarding the next one concerning aqsam al-waratha bi'itibar al-jins. Regarding concerning that, who are those people that now in some little more detail that can inherit from each other. So he mentioned aywa.
The son of the son.
This I mentioned that al-warithuna min al-dhukur ashara. Even though the ulama mentioned that's concerned, that is in summary. So what he's going to give you, so that they divide him into two categories concerning these. You have the first group of 10 and the larger group of, in more detail, they reach 15 amongst the male. But he mentioned here, ijmalan, which is 10, the larger group goes to 15. Aywa.
The son of the son.
So that's 1, 2.
And so forth in a descending lineage, for Allah exalted be He says, Allah instructs you concerning your children, i.e. their portion of inheritance, for the male what is equal to the share of two females. Surah Nisa, ayah 11. The grandson is the same as the son. This is due to Allah's statement, O children of Adam. Surah Al-Araf, ayah 26. And also Allah exalted be He says, O children of Israel. Ayah 40 of Surah Baqarah. Number 2, the father, the paternal grandfather, and any forefathers of the paternal grandfather.
So that's 3, 4. So yeah, father and grandfather.
This
3 and 4.
Hey, 3 and 4, anyway.
So
son
son.
and son. So you have son and grandson. So you have son, grandson. That's 1, 2 of the 10.
Okay.
And then you have now father and grandfather.
This is because Allah exalted be He says, and for one's parents, to each of them is a sixth of his estate. Surah An-Nisa, ayah 11. Moreover, the paternal grandfather is the same as the father, for the Prophet ﷺ judges that he inherits 1/6 of the estate, the same as the father.
It's the one thing go back to the hadith of Ma'qil ibn Yasar that mentioned this. Even the hadith that mentioned, but I mentioned لأبوي لكل واحد منهما سدس. So I mentioned لأبوي. So أبوي mean concerning father and grandfather. Father and grandparents. So father and grandfathers. So that's 3, 4, A1.
Brother, whether he is full or half brother.
So that's the 5th.
This is because Allah exalted be He says, they request from you a legal ruling. Say Allah gives you a ruling concerning one having neither descendants nor ascendants as heirs. If a man dies leaving no child but only a sister, she will have half of what he left, and he inherits from her if she dies and has no children. Surah Nisa, ayat 176. This verse refers to brothers who have different mothers. As for those who have the same mother but have different fathers, Allah exalted be He says, and if a man or woman leaves neither ascendants nor descendants but has a brother or a sister, then for each of them is a sixth. Surah Nisa, ayat 12.
So it mentions concerning al-akh al-mutlaq. Al-akh mutlaqan, in the sense of those brothers could be that they said the shaqiq, where same mother and father, that's shaqiq. So your full blood, if you want to use that term, then you can find that could be brothers by way of the father and separate mothers. or it could be that you're brothers by same mother, different fathers.
Yeah.
So all of those are those three types. So same brothers, same mother and father, same father and different mother, same mother, different fathers. All of those are considered to be brothers, but different degrees. And so that's one set. Aywa, that's the sixth of the 10. Aywa, the fifth. The fifth.
The son of a full brother or the son of a half brother from the same father. As for the son of the brother who has the same mother of the deceased but a different father, he does not inherit because he is one of the blood relatives.
Yes, that's the sixth. Ibn Akh. Aywa.
The father's full brother, paternal uncle, and the father's half brother from the same father, and the son of the aforesaid paternal uncle, cousin, and so forth in descending lineage.
So be paternal uncle and what? No. Hey, and his son. And his son. We call them cousins.
Yeah.
Aywa.
However, the father's half brother from different
So that
fathers.
would be 8, that would be 7. That would be 7, 8. That would be 7 and 8. Aywa.
However, the father's half brother from different fathers does not inherit from the deceased. To illustrate, the Prophet ﷺ said, "Give the shares of the inheritance prescribed in the Quran to those who are entitled to receive them. Then whatever remains should be given to the closest male relative of the deceased." Next one, the husband, for Allah exalted.
That would be the
he
9th.
says,
That would be the
"And
9th.
for you is
Would be
half of what your wife leaves." Surah An-Nisa, ayat 12.
So the 8, 7 and 8. So 7 is the full.
There's the uncle there.
The father's full brother and the father's half brother from the same father, and then
His
son and the son of the aforesaid paternal uncle. That's 7 and 8.
Read what?
Yeah.
Yeah.
No.
Yeah?
Now the
7 and 8
لغاية.
was the father's full brother
Yeah,
and the father's half brother.
yeah, and then
5 and 6.
No, this.
Okay, that's in it. So that's
What's before
7.
Zawj? What's the one that you have before Zawj? Before the husband?
Before husband.
Yeah.
Father's full brother
Yeah,
and the father's half brother.
and then keep reading.
And the same father, the son of the
From the
aforesaid
same
paternal.
father.
Yeah.
From the same father.
Yeah.
And then he says,
The son of the aforesaid paternal uncle. So
The uncle
two
you have
cousins.
so you have 7, 8. 7, 8 will be لغير
the and other than them.
Yeah, from not the same mother. So your uncle, and then your
The
cousin.
8.
Yeah,
Okay.
uncle, and
Radel is the 8.
yeah,
Okay, get it.
the 9 being the husband.
Husband.
Now,
There you
Number
are.
10, the emancipator who has the right of the wala or his heirs. For the Prophet sallallahu alaihi wasallam.
That's it. No, he's past husband. Hey, red husband, yeah.
It's the emancipator who has the right of the wala or his heirs. For the Prophet sallallahu alaihi wasallam said, "The wala, i.e., loyalty by virtue of emancipation, is a bond like that of kinship." He sallallahu alaihi wasallam also said, "Verily, the wala is for the emancipator."
Hey, so those are the 10. So said that is the ijmalan, they're 10. Tafsilan, in more details, they go to 15. Aywa.
Female inheritors are 7.
So those are the males. So now we're going to discuss that. Those are the list of males, inheritors. Now we're going to discuss the female side of things.
The daughter.
Should I mention how many? 7.
7.
So that's the ijmalan. But the number actually goes up to
15.
10. No, for female goes up to 10. And the man it goes up to 10. So an additional 3 to the woman, an additional 5 to the man that were mentioned before.
The daughter of the son, the daughter, and any female children descending from the male lineage. To illustrate, Allah exalted be He says, "Allah instructs you concerning your children, i.e. their portions of inheritance, for the male what is equal to the share of 2 females. But if there are only daughters, 2 or more, then for them is 2/3 of one's estate. And if there is only one of them, for her is half. Surah Nisa, ayah 11.
So as concerning the first, you have 1 and 2 will be bint ibn. So what? Daughter and the son of the...
Granddaughter of the son.
Aywa. Those are the first two. Aywa.
The mother and the grandmother. For
So
Allah exalted be He says, but if you had no children and the parents alone inherit from him, then for his mother is 1/3. And if he has brothers and or sisters, for the mother is a 1/6. Surah Nisa, ayah 11.
Yes, that's wal Jid. So mother and grandmother.
Buraidah, may Allah have mercy on him, narrated al-marfu, traceable hadith stating that the Prophet ﷺ said, the grandmother of the deceased is to be given 1/6 of the inheritance if the mother is not alive, related by Abu Dawood.
In that hadith, can someone to find that some of the ulama, like our note of contemporary, or the hadith to be Hassan, based upon shawahi, but the hadith is daif, but based upon other narrations, all the hadith to be Hassan, and Shaykh Al-Albani rahimahullah, regarding the hadith, say it is daif. So the original hadith is daif, but others will all the hadith to be Hassan, based upon similar narrations. Aywa.
The sister, whether a full or a half sister, for Allah exalted be He says, and if a man or woman leaves neither ascendants nor descendants, but has a brother or a sister, then for each of them is a 1/6. Surah Nisa, ayat 12. Allah also says, if a man dies leaving no child but only a sister, she will have half of what he left. And if he inherits from her, if she dies and has no child, but if there are 2 sisters or more, they will have 2/3 of what he left. Surah Nisa, ayat 176.
أيوة. تفضل شيخ.
الله أكبر الله أكبر الله أكبر الله أكبر أشهد أن لا إله إلا الله.
نعم تفضل. So we continue. So we mentioned that al-ukht, al-mutlaq. So mentioned that either that sister could be a full sister or half sister, by way of half, could be by way of the father's side or by way of the mother. Aywa, that's the 5th.
The wife, i.e. the widow, for Allah exalted be He says, and for them, i.e. the wives, is 1/4. Surah Nisa, ayat 12.
Yeah, that's the 6th.
The female emancipator inherits from the slave she has freed due to the right of the wala, as the Prophet ﷺ said, verily the wala is for the emancipator.
Yes.
The aforesaid list generally covers the number of possible male and female inheritors, but in detail there are 15 male inheritors and 10 female inheritors. One may check the references of Sharia Islamic law for more details in this regard, and Allah exalted be He knows best.
So Shaykh Yahfidullah, you mentioned 10 for the men and 7 for the women. I would say that's ijmalan. That is mentioned amongst the ulama, but the full number goes to 15 for the men and 10 for the females. So the intent here is going to give a general overview regarding the ahkam of inheritance. Give an overview of the ahkam of inheritance. Aywa.
Types of inheritors according to their shares of inheritance. Inheritors according to their shares of inheritance are 3 categories. Number 1, those entitled to specify prescribed shares that do not increase unless through the rad, or decrease unless through the reduction of their heirs' shares. Number 2, Agnant relatives, those whose shares of inheritance are not defined. Number 3, blood relatives. They are to inherit when there is none entitled to prescribed shares except for the spouses and when there are no agnant heirs.
So you mentioned in regard considered as for the sharing or the distribution that either the person, the portion that one receive, will fall under said al-fard, which is al-furud, where the person get a fixed amount. So certain people, the amount that they receive, it is fixed. So that fixed amount could be at times could be in the Quran mentioned 6 of so either half, a rub, a quarter, thumun, 1/8, or it could be thuluthan, or times 2/3. It could be a third, thuluth or sudus. So those ones are somewhat fixed. Those ones are somewhat fixed. For certain people, what they receive is fixed. Then the second group of people concerned that asaba, where they receive but it is not fixed. So depending on other factors, but they will receive something, but there's no fixed that amount that they receive. What they receive is due to other factors. Then they'll get. And the third dimension, Dhul Arham, are concerned that the blood relative also that they receive an unfixed also amount. So the amount, if there's no one that from the fixed amount or the unfixed amount, then they get what remains. Aywa.
Those entitled to prescribed shares are 10. Spouses, parents, paternal grandfathers, daughters of the son, sisters, whether full sisters or half sisters, and brothers and sisters who have the same mother. Each one of those entitled to prescribed shares will be explained in detail.
Hey, so that's concern of the furud, of those who get a specific amount or share. The Shaykh Hafidullah will discuss those one first. So and they fall into 10 groups. They fall into 10 group of people that receive this fixed amount, and those will be discussed individually. So inshallah ta'ala, we'll stop here and then continue next week. Bidnillahi ta'ala, wa billahi ta'ala tawfiq. So that's this general thing concerned that you'll find that in some book, and the Shaykh also in this book, I'm not sure in your book, do they have like diagrams?
No.
There's no diagram? At some point.
At some point there's some diagrams, but that's
Later on.
That's later on.
Okay.
Should have came down.
Yes, and some book give diagrams so you can have a little idea what's.
Idea what's coming.
Yeah, but the diagram with this one come a bit later.
In chapter 14, in the inheritance of siblings with a paternal grandfather, and then you start seeing a little bit of that.
Okay.
And that's all I see.
Comes to the general idea, just going to give a person a general idea as to